Fred Brunner versus Melanie Sterling, A923202.
Morning, Your Honor. Aaron Maurice on behalf of the plaintiff.
Good morning.
Morning, Your Honor. James Jimmerson, bar number 12599, on behalf of defendants Melanie Sterling in her individual capacity as well as trustee for the Melanie Sterling Trust, as well as Mr. Shanta Cotrick.
Good morning. All right, it's your defendant's motion to dismiss.
Morning, Your Honor. In 2014, a married man walked into a Las Vegas strip club, walked out with a new girlfriend, and now he has the temerity to tell this court that he's the victim. That is nonsense. This is nothing but a case of sour grapes between plaintiff, Mr. Brunner, and my client, Ms. Sterling, who had been in a relationship from approximately 2014 through 2024. After those 10 years, the relationship was at a crossroads. And in the end, Ms. Sterling chose to take the proverbial Saturday morning leap and ended the relationship. What did Mr. Brunner do in return? He sued Ms. Sterling, first in Arkansas, and when that was dismissed for form nonconvenience, here in Nevada. Mr. Brunner is seeking to claw back all of the monies that he had spent on my client during their relationship, including, and most importantly, Judge, the home that my client lives in. That home that is titled in her name and her name only, or that was titled in her name and her name only, until she deeded it to her trust. That's right, Judge. Pen in hand, because Mr. Brunner paid for the home, he deeded that property to her and to her alone. And that's what this dispute is really about. It's about my client's home and her right to live there, to own and possess it free of Mr. Brunner's interference. Mr. Brunner, however, knowing that he is not on title, asks this court to treat him as if he is a 50% equity holder in that home, because he was in a relationship with my client. That sort of claim is...
I don't think it was because he's in the relationship with her. I think the idea is because he gave her a bunch of money, not only the home, but then above and beyond that, he invested more monies in it. And it's not, he doesn't think it's not like he's looking for marital split. He's looking for his investment back, I believe, which is different.
And that's the thing, Judge, that you're right. Okay, when you talk about marital split, this is a claim that is more frequently heard before Department R in Family Division than it is before Department 18 in Civil Division.
I don't disagree.
And you know, call it serendipity, Judge, you know, call it drawing the short straw, but we're here in front of Your Honor because the parties weren't married. They didn't have children. They were never engaged. Mr. Brunner never asked Ms. Sterling to marry him. They never lived together, Judge. They never even lived in the same time zone. And those are the facts that the court should find cause this court to dismiss this matter in full. The principal claims that Mr. Brunner is asserting are those based upon a fiduciary duty. That is, Mr. Brunner claims that there existed a fiduciary duty between my client, Ms. Sterling, and himself during this 10-year period between 2014 and 2024. In fact, there are several claims that all rest on the existence of the fiduciary duty, and which this court can, as a matter of law, make a finding that no such fiduciary duty existed. That is the breach of fiduciary duty claim, the aiding and abetting breach of fiduciary duty claim, the constructive fraud claim, and the constructive trust claim. Each one of those claims requires the plaintiff to establish the existence of a fiduciary duty between Ms. Sterling and himself. But there is no Nevada law that establishes the existence of a fiduciary duty between a boyfriend and a girlfriend. In fact, There is no law that Mr. Brunner has cited at all anywhere in this country that so establishes such a relationship. The closest they can come, Your Honor, is Fick v. Fick, which, once again, a family court case concerning spouses, or excuse me, at that point in time, fiancés who were negotiating a prenuptial agreement, in which the Nevada Supreme Court held that fiancés have a fiduciary duty towards one another within the context of negotiating that agreement and disclosing each of their respective assets. This case is nothing like that case. And in fact, because there is this absence of case law, this court should find that there exists no fiduciary duty. Not just because of the absence of case law supporting it, but because of the facts. Mr. Brunner was the wealthy, sophisticated individual in this relationship. He proudly admits that he paid for all of these things, including Miss Sterling's home. Mr. Brunner was the one with sophistication. Mr. Brunner was never dependent on Miss Sterling, which is a requirement of a fiduciary duty. A fiduciary duty is characterized by a relationship in which there is a superior or dominant party and then a dependent party that is uniquely reliant and uniquely trusting of the dominant party. Mr. Brunner was never such a dependent. He was the one who paid for everything. He cannot be found as a matter of law to have had this fiduciary relationship with my client, especially in the face of not a single decision that would support such a finding.
I'm not leaning towards the fiduciary duty, confidential duty part of this. I am looking more closely at the equitable theories more so.
And I want to get into that, Your Honor. The equitable theories in terms of constructive trust also requires a fiduciary duty. And that's...
How about promissory estoppel, partial performance?
Those theories, first of all, Your Honor, and I appreciate the court's close reading of the briefs because those matters were addressed in our motion and Mr. Brunner's opposition addressed specifically promissory estoppel. In the context of promissory estoppel, Your Honor, to defeat the statute of frauds claims, okay, and that's the second reason why the court should dismiss, because there is no written document, certainly no written and signed document, sufficient to establish an equity interest in real property as required by Nevada law. The attempt to circumvent or look past that statute of frauds requires either a fiduciary duty to establish constructive trust, which there is no authority cited by Mr. Brunner anywhere. Again, there was a fairly national search, as the court can appreciate, for authority concerning this matter that would establish a constructive trust in the absence of a fiduciary duty. And therefore, the only other example or only other basis that Mr. Brunner asks this court to find that the statute of frauds does not bar the claims concerning the real property is based on promissory estoppel. However, there is no case law cited by Mr. Brunner that would substantiate or support his argument. In fact, the only authority the court has comes from the defendants themselves, specifically the Nieto case, which talks about the fact that promissory estoppel is ordinarily not an exception to the statute of frauds, and in fact is only an exception in very limited circumstances. Specifically, as the Summa Corporation versus Greenspun decision in 1980, the Nevada Supreme Court established that in order to have a promissory estoppel claim circumvent or get around the statute of frauds is when there are specific acts or specific conduct that would be in furtherance of an agreement separate and apart from the other conduct or the other acts of that same individual. And in this case, because Mr. Brunner had given so many gifts, had paid for so many things, the act of simply paying for something like a home would not satisfy promissory estoppel because his acts weren't in furtherance or weren't supportive of a clear agreement, but instead simply a continuation of his prior pattern and routine. That is, to pay for things and to be generous with his wealth. My clients are certainly not arguing that he was not generous with his wealth, but this case rests entirely on an after-the-fact recharacterization of the gifts. That is, that these were conditioned on something for which there is no evidence. And when you require, as a matter of law, a writing to substantiate an ownership interest in real property, you cannot simply claim an oral agreement allowed me to claim a 50% interest in this real property. Not when the acts that would otherwise substantiate such an agreement would also substantiate all of the other activity. Well, support his pattern and practice of paying for things and giving her gifts. There was nothing different about the gift of purchasing the home for her. And in fact, Your Honor, the reason why it is so important that the court look at the fact that he paid for it all is because he had the ability to title it however he wanted.
I agree with that part. I agree with that part. The sophisticated businessman buys somebody a house and puts it in her name. To me, he buys her a house and puts it in her name. Having said that, I also am looking at to figure out, I mean, if he thought he had this relationship with her for 10 years, it seems like a fairly complex fraud if it were a fraud. But if from the get-go, she's telling him, yeah, you're the love of my life, we're together, blah, blah, blah. But at the same time, she's living with this other guy and lying and stuff. Part of me says that's something on a different level. So that's kind of where I'm struggling a little bit. If she's blowing smoke, lying, whatever, leading him to believe that they're having this relationship that she's really not having, and she's actually having a relationship with someone else unknown to him. I still have to reread some of the cases because I don't know legally. I just know it doesn't feel right to me.
I understand.
So I don't know. That's kind of where I am.
And I want to address the specifics of the complaint to address the court's concerns, because I think the court is right in its approach. There should not be a finding that there's a breach of fiduciary duty. Those claims should be dismissed. And the claims concerning the home should be dismissed because of the requirement of statute of frauds. But as it pertains to what I would consider to be the remaining gifts or the remaining payments for which they are alleging were based on fraud or fraudulent misrepresentation of the status and nature of the relationship, I can understand and appreciate the court's position. Because ultimately the court at this stage has to accept what the plaintiff says is true. And we know, by the way, Judge, okay, notwithstanding that Mr. Brunner certainly was not standing in front of the truth police when he was signing the verification, as evidenced by the contradictions within his own versions of the amended complaint from Arkansas to Nevada.
No, but I'm gonna go ahead and assume if in fact she's having this relationship, full-blown relationship with someone else, he's probably not throwing her money like that. So
Correct.
I think he probably didn't know. And again, these are all factual issues, and I don't even know what the. Again, I have to reread some of the stuff. Right now, I'm just kind of in my gut, it feels like he absolutely bought her the house with no strings attached. And I don't believe for a minute that when he initially bought her the house, he intended to get half of it back. But what was his incentive and why did he do that? What was she telling him? Was it true, untrue? And then all the money's towards it after that, then maybe that changes.
And I want to address just a little bit of this, and I think the complaint, while it is certainly long and has several examples of what he claims to be misrepresentations, the essence of this claim is the statement that my client made representations to him that they were in a quote serious long-term monogamous romantic relationship. That phrase was used dozens of times in the complaint. And the basis for that allegation, first of all, there was never an allegation she actually said those words, but that the thrust of the message was made and was made by my client in that she had sent 6 text messages to Mr. Brunner, 3 from 2014 and 3 from 2020 through 2022. And the reason dates are important here, Judge, is because Mr. Brunner, certainly for the 2014 text messages, was still married. In fact, he was not only still married to his wife at that time, she hadn't even filed for divorce yet, Judge. That divorce proceeding wouldn't conclude until 2016. So the notion that he would rely upon a representation that they were in a monogamous or exclusive relationship when he himself was still married and divorce proceedings had not even commenced.
Yeah, but people can be separated for ages before they follow up with the official. They can be emotionally done without being.
And you're right, Your Honor, perhaps it will require additional facts to support it. But ultimately, because fraud requires a pleading with particularity, or it's a heightened pleading standard, we would submit to the court that the pleading itself is efficient on its face. And while we would certainly resist any effort to amend, if the court makes a finding that he has a right to amend, we will then deal with the additional allegations later. And the other reason I cite these 6 text messages are the subsequent text messages, the one identified from 2020, 2020, and 2022, are all post the purchase of the home. So there could not be a fraudulent basis for which he would have purchased the home for her, because those text messages or those communications hadn't happened yet. The home was purchased in 2019. So with that, Your Honor, we believe that the court is appropriately looking at this. That is, there's no breach of fiduciary duty claim and no claims whatsoever that are based on a fiduciary duty, that the statute of frauds bars any ownership interest, any claims thereon on the real property, and that as pled, the fraud claims, which, Judge, I will tell you, there certainly were no misrepresentations, and I think the court, when discovery commences, if the court does not grant dismissal in full, will see what the true facts are. But the complaint as pled fails to satisfy the pleading standard under 9B.
Some of the facts are going to change. I mean, presumably, she's telling him she's one place and then she's posted that she's somewhere else. I mean, that seems pretty much.
Certainly,
My guess is that's probably going to be how it is.
correct, but there are certain additional facts
And that isn't right.
So, in Your Honor, I would respectfully submit that the version of events as presented to this court is not only incomplete, but is materially incomplete. And that when the court gets the full picture, the court is not going to be taking the same position or same point of view as it is now, because it will have the benefit of all the facts. So with that, Judge, we respectfully request the court dismiss the matter.
Good morning, Your Honor. Eloquent presentation by Mr. Jimmerson. I think it's probably forecast where he'll go with a closing argument at the end of a trial, or potentially in favor of a motion for summary judgment when there is actually a factual record that this court can review. In other words, when there's evidence before this court. What we're dealing with here is a bit of a procedural mess. The original motion, labeled a motion to dismiss under NRCP 12B5, took an interesting position. The first thing it did was it attached 67 pages of unauthenticated exhibits. That's what's attached. It's unusual to see a motion to dismiss attach exhibits unless those exhibits are specifically referenced in the complaint, and none of those exhibits were referenced in the complaint. And then what the defendants do is they spend about 4 pages of their motion to dismiss mischaracterizing the complaint. We heard Mr. Jimmerson kind of carry that theme through today. He sets it up as, this is just an angry ex trying to claw back all the money that he gifted to the defendant, to Ms. Sterling. That's not our complaint at all. My associate had the benefit of reading Mr. Jimmerson's motion to dismiss before I did, and she immediately told me, she said, yeah, they're not moving to dismiss the complaint we filed. They're moving to dismiss the complaint they wish we filed. So when we looked at this motion, and I mean, again, and we didn't hide this fact when we responded to it. I mean, we pointed out the fact that they spent 6 pages arguing statute of frauds to establish the fact that you can't sue for breach of an oral contract related to the conveyance of an interest in real property, when if you look at our complaint, there's no cause of action for a breach of oral contract related to a conveyance of an interest in real property. But so when it came time to oppose the motion, we had a tough choice. Do you oppose it as if it is what it's labeled to be, which is a motion to dismiss under NRCP 12B5, or do you say, well, they've got all these exhibits attached to it, so we're going to treat it as those are exhibits that are not referenced in the complaint, so we're going to treat it as a motion for summary judgment that just happens to be based on these exhibits. And ultimately, we determined to respond to it as if it was a motion to dismiss. And we did so because, one, we like our complaint. We spent a lot of time drafting that complaint. I know Mr. Jimmerson likes to point to, this text and that text and the date of this text and the date of that text. The problem for Mr. Jimmerson on that point is what we're pleading is a long con. It's a long con. It is a 10-year fraudulent conspiracy. That's what we're pleading. It's similar to a Ponzi scheme. When you plead a Ponzi scheme, you have to understand that every single statement that is made in furtherance of that Ponzi scheme is fraudulent, just as every single statement that is made in furtherance of the long con, which Ms. Sterling and Mr. Coatwright carried out here, is in furtherance of that scheme. So when she sends a text that ends with, I love you, when she starts a text with, I miss you, our allegation, because what we're pleading is a long con, is that each and every one of those statements is in fact a misstatement in furtherance of a fraud. I can't file a 1,000-page motion that details every single statement she made over a 10-year period that we say is fraudulent. And I'm not required to do so, just as in a...
Just curiosity,
Yes.
how often do they see each other?
I don't know, Your Honor. I believe on a near monthly basis. I have a feeling that if you were to ask me that question when we're arguing a motion for summary judgment, I'd have a factual record that I could actually respond to that. But I do not know the answer to that. So when it came time to respond to this, we looked at this and we said, okay, we like our complaint. We like the 12b-5 standard. It's very deferential to the plaintiff. All facts alleged in the complaint must be accepted as true. Every inference in favor of the plaintiff. And so we said, okay, that makes sense. And then the other thing was the exhibits, although they attached the 67 pages of unauthenticated exhibits, they really didn't rely on it in support of the arguments that they advanced in the motion, right? I mean, they attach it. I don't know if they attached it because they wanted to kind of poison the well. I don't know what the purpose was, but when it came time to make the arguments, they didn't focus or cite to those exhibits. What they did was they just misrepresented the allegations that were in the complaint and argued that based on their version of the allegations in the complaint fails to state a cause of action upon which relief can be granted. So we say, okay, we're going to respond to this as if it's a 12b-5 motion. And we followed kind of a rhythmic formula in our response, which was in almost every single section it would say, well, first of all, in the factual section, we just took the facts directly from our complaint. Literally just they're in chronological order, cited every single one of them, said this is what's been alleged to exist in this case. This is what this court must accept as true for purposes of this motion. And then when it came to the arguments, what we did is we would say, this is the argument that they have made as to why the claims in the complaint fail. That is not what we in fact alleged in the complaint. Here is what we in fact alleged in the complaint. These are the elements of that cause of action under Nevada law. Therefore, if you accept the facts as we alleged, not as misrepresented in the motion, we have stated a cause of action upon which relief can be granted. The only two instances in which we kind of ventured out of this formula were to deal with the argument about the statute of frauds, making it clear that no, we did not plead a claim for breach of contract. What we did was we asserted a series of claims that would serve as the basis for a constructive trust or an equitable lien, either of those equitable remedies, and that the statute of frauds presents no obstacle to that requested relief. And then we dealt with the heart bomb statutes. They had a whole section in there where they argued that the repeal of what are known as the heart bomb statutes somehow serves as a get out of jail free card for the defendants. In other words, saying you can't sue because these parties were involved in a romantic relationship that ended. You can't sue for fraud. And we pointed to the case out of Ohio. It's an Ohio federal court case where somebody made that exact same argument. They had the exact same repeal in Ohio, and they made the exact same argument. And the federal court in Ohio said, absolutely not. Just because these parties were involved in a romantic relationship does not mean that the defendant is somehow shielded from a fraud claim. If she defrauded him, then in fact, that's a claim that is actionable. There were some procedural issues that then caused that to go back and forth, but that was an issue we addressed in our opposition. So at the end of our opposition, again, we stuck to 12b-5, argued exactly what the facts are alleged in our complaint and what the case law provides in Nevada. And what we were hoping we would see is that in the reply, they would actually address the claims that we have asserted in our case in our complaint and the facts as we have alleged them in the complaint. And that's not what happened. Instead, what they did was they filed a reply, what's it like 25, 26 pages, where not only did they go back to trying to argue their version of our complaint as opposed to the actual allegations in our complaint, but what they did was now in the argument section, they actively cite to the 67 pages of unauthenticated exhibits. So in the reply, what they did not do in the motion, they do in the reply. They are now citing to allegations in complaints that were filed in Arkansas and saying, you must accept these as facts. And where they didn't have facts on to fill those in other words, where there were things that the Arkansas action had made no mention of, they would just provide the statements of counsel. And by far the greatest example of this occurs on page 12 of their reply. It's in footnote 8. This is literally a sentence in their reply. As this court knows, Sterling and plaintiff were never engaged. They never applied for, let alone obtained a marriage license. Sterling has never been pregnant with plaintiff's child, let alone had a child with plaintiff. Sterling did not apply with plaintiff for a mortgage for her home, and there was no understanding that Sterling's home would be the marital domicile. Plaintiff never lived with Sterling at all, let alone in the home in dispute. Now, there's no citation to that. There's no citation to facts, not even to those 67 pages of unauthenticated exhibits. That is just a statement of counsel. And we see this throughout the reply. It is literally, and we heard Mr. Jimmerson today stood up and said, Your Honor, they never even lived in the same time zone. Again, I look forward to arguing the facts of this case and the law in Nevada. I do. But right now, you don't have any facts. What you have is what do we have, like a 29-page complaint with 209 allegations stating 9 claims for relief. That's what you have.
Talking about the fiduciary duty. Please.
Okay. The fiduciary, it's interesting. Mr. Jimmerson makes the representation to the court that the fiduciary duty claim he describes as kind of the key. Says it's the key. You can't get a constructive trust if you don't have a fiduciary duty. That is not accurate. And I do want to make it clear that we both characterize the Fick case in a different way. Mr. Jimmerson says the Fick case says that you cannot have that a fiduciary duty exists between fiancés, but it doesn't exist between a man and a woman who are dating but who are not engaged to be married. That's an interesting way to read Fick. All Fick does is acknowledge that there are circumstances in which a fiduciary duty can exist between fiancés. We describe it in our opposition as we say, hey, Fick establishes that a fiduciary duty can exist between an unmarried couple. That's the way we characterize it. Mr. Jimmerson characterizes as no, Fick stands for the proposition that you must be engaged. I think the truth is I think both of those statements can be true. The reality is Fick does not say that a fiduciary duty cannot exist between a man and a woman who are dating. It does not say that. It recognizes that a fiduciary duty can exist between fiancés, but it does not exclude the existence of fiduciary duty in other scenarios. And here's why this is important. I guess I need to make another point. I will get right to what you're talking about. Mr. Jimmerson today pointed out the fact about this whole idea that to have a fiduciary duty, you must have an unequal power. There must be a difference in the power between the parties. That is not accurate. That is a statement that they cited in their reply. It comes from the Hammergren case. I don't know if the court is familiar with the Hammergren case. It is a terrible case, a fact pattern that is beyond belief. Dr. Hammergren has a woman patient who comes to see him. He diagnoses her with MS and tells her that if she wants to continue to have the use of her legs, she must have a life that is completely free of stress. He then prescribes her just a laundry list of terrible medications, Valium, Quaaludes. Like it is unbelievable. It was back in the 80s. He then, like 4 weeks later after the initial appointment, contacts her and asks if he can take her out to dinner. He does. A sexual relationship develops between them. And according to the complaint, on basically a monthly basis, Dr. Hammergan would go over to the plaintiff's house, engage in sexual relations, and he would bring drugs to the house, again, all under this idea that she needed to have this stress-free life and there should be no conflict in her life. She then moves to Ohio, goes to a doctor to obtain a prescription for these same drugs, and finds out she actually doesn't have MS. In other words, Dr. Hammergan had misdiagnosed her with MS. She sues Dr. Hammergan. Dr. Hammergan moves to dismiss. The district court grants the dismiss on the she sues for breach of fiduciary duty. Dr. Hammergan moves to dismiss. The district court grants, finding there is no authority that says a doctor owes a fiduciary duty to a patient. And the Nevada Supreme Court says, yeah, under these facts, a fiduciary duty existed, and she does have the ability to sue, and they remand. The reason I bring this up is the quote that they use in their reply, which Mr. Jimmerson kind of repeated today, this idea that there must be disparate power between the parties. The only place you will see that quote in any related to the Hammergan case is in other cases around the country where you're dealing with these kind of inappropriate relations between a doctor and a patient. If this court looks at modern Nevada Supreme Court authority related to fiduciary duty, far different. First case, we have Valley Health Systems versus Murray, 544 Pacific 3rd 904. This is a 2024 Nevada Supreme Court case. There, the court says a fiduciary relationship exists when one places heightened confidence in another, such that the latter must then act in good faith for the other's benefit. And the citation that they use for that is Long versus Town, which is 98 Nevada 11, 639 Pacific 2nd 528, and that is a 1982 case that discusses the elements for a claim for constructive fraud. And here's why that's important. We have asserted a claim for constructive fraud in this case, Your Honor. If you look at that case, the Long versus Town case, again, far from this disparate powers, that Mr. Jimmerson describes, on page 13 it states, constructive fraud is the breach of some legal or equitable duty, which irrespective of moral guilt, the law declares fraudulent because of its tendency to deceive others or to violate confidence. Constructive fraud is characterized by a breach of duty arising out of a fiduciary or confidential relationship. This is a key point. Mr. Jimmerson makes it sound like the breach of fiduciary duty claim is the linchpin in our claim for a constructive trust. That is not true. We repeatedly allege throughout the complaint that the parties shared a confidential relationship. The Long versus Town case goes on to say a, quote, confidential or fiduciary relationship, end quote, exists when one reposes a special confidence in another, so that the latter, in equity and good conscience, is bound to act in good faith and with due regard to the interests of the one reposing the confidence. By far, the case that is that deals with this issue of a confidential relationship in Nevada is Perry versus Jordan. That's 900 Pacific 2nd, 335. It's a 1995 Nevada Supreme Court case. There, the court says, quote, persuasive authority suggests that a confidential relationship may arise by reason of kinship or professional business or social relationships between the parties. Think about that. We're not talking about a difference between, this is not a situation where you have a doctor getting sued by a patient for inappropriate relations. We are now talking about what it means to have a confidential relationship. And this is the Nevada Supreme Court recognizing that these relationships may arise, quote, by reason of kinship or professional business or social relationship between the parties. Such relationship exists when one party gains the confidence of the other and purports to act or advise with the other's interest in mind. It may exist, although there is no fiduciary relationship. It is particularly likely to exist when there is a family relationship or one of friendship. Again, not talking about disparate power, which is what Mr. Jimmerson wants to focus on. This is the Nevada Supreme Court recognizing that this confidential relationship can exist amongst in family relationships or one of friendship. The court goes on, and Perry goes on to state, when a confidential relationship exists, the person in whom the special trust is placed owes a duty to the other party similar to a duty of a fiduciary, requiring the person to act in good faith and with due regard to the interests of the other party. And I promise, Your Honor, the last case I'm going to read to you is Giles versus General Motors Acceptance Court. This is a federal court here in Nevada. Pardon me, this is the Ninth Circuit Court of Appeals dealing with a case in Nevada. There it says, when a confidential relationship exists, the person with whom the special trust is placed owes a duty to the other party similar to a duty of a fiduciary, requiring the person to act in good faith and with due regard to the interests of the other party. A confidential relationship may exist, although there is no fiduciary relationship. It is particularly likely to exist when there is a family relationship or one of friendship. Demonstrating a confidential relationship fulfills the fiduciary duty element of actions for constructive fraud and undue influence. Again, we've asserted a claim for constructive fraud. One of the remedies you can get if you establish a claim for constructive fraud is a constructive trust. A claim for constructive fraud does not require that you establish a fiduciary duty. Says it's a fiduciary duty or a confidential relationship. And the Nevada Supreme Court authority is clear that a confidential relationship can exist. I mean, there are literally cases in Nevada where a confidential relationship has been found to exist between friends and neighbors. And I was going to say the last part of that case, I'll just read the last sentence here. And this is the Giles versus General Motors Acceptance Court case. It says, in Perry, the Nevada Supreme Court found a confidential relationship between two, quote, close friends and neighbors. Your Honor, I recognize that Mr. Jimmerson does not agree with probably 98% of what's written in our complaint. I understand I understand the defendants dispute the factual allegations that are contained in the complaint. And those are the kind of things, that's the reason why you do discovery. The reality is we're not there. What you have before you is a motion that is labeled a motion to dismiss under 12b-5. And if you want to treat it that way, then it must be denied because the allegations in the complaint absolutely satisfy if they are accepted as true, they would absolutely satisfy the elements for the causes of action that are asserted therein. If you want to treat it as a motion for summary judgment, Your Honor, you have to deny it because there's absolutely no admissible evidence before this court. The 67 pages of unauthenticated exhibits, that's not admissible evidence. There's not a single declaration before the court. There's not a single deposition before the court. All you have are the unsubstantiated statements of counsel. And the last argument I want to make is the second to last argument. The other best example of the unsubstantiated statements of counsel is found in the reply related to the arguments of gifts. You heard Mr. Jimmerson stand up to you today and say, these were gifts, Your Honor. These were gifts. 10 years worth of gifts. They want to claw back these gifts. Page 21 of the reply, line 3, the defendants write, plaintiff's unjust enrichment claim fails because the property plaintiff now seeks to recover were all gifts to Sterling. Plaintiff, now upset that Sterling is no longer his girlfriend, cannot retroactively revoke the gifts he gave to her. If you review our complaint, the complaint we actually filed, the word gift is not used one time. And there is no evidence before this court that any of the items that the plaintiff gave to the defendant were gifts. And I understand that is the defendant's theory of the case. And I understand that's what they're going to need to use discovery to establish. And I understand that the next time we're back here in front of you, we'll probably be arguing motions for summary judgment, and there'll be evidence in front of you to that effect, whether they were gifts or not. But the reality is you don't have that yet. What we have right now is a complaint which validly states the causes of action that are asserted therein. The last point I wanted to make, and I promise this one will be brief. It is clear from the filings that defendants struggle with the fact that we have identified as our first claim for relief, constructive trust. And our second claim for relief references an equitable lien. And they say these are not causes of action. These are equitable remedies. We do not dispute that those are equitable remedies. Attorneys who practice in the area of title law, real property law will tell you, you never, if you're going to be requesting equitable relief related to real property, whether it is constructive trust, equitable lien, and equitable easement, you do not just include those in your wherefore paragraph at the end of the complaint, which is where you normally put the relief you're requesting. The reason you don't do that is because you're going to record a lis pendens, which we did in this case, that is supposed to put the world on notice as to the allegations that have been made in that action, and you want to avoid a BFP argument down the line. And if you just include a sentence on page 28 of your complaint that says, we're requesting a constructive trust, or we're requesting an equitable lien, you're basically opening up a second front. You run the risk that if the property is transferred, somebody's gonna say, I saw the lis pendens, but how did I know you were requesting this? So not only do you put that, you identify it as a claim for relief, not a cause of action, which is what we did. It's identified as a claim for relief, and you put it front and center. That is the reason why the constructive trust claim is the first claim for relief. That is why the claim for relief that references an equitable lien is the second claim for relief. Again, you're not going to see me at the end of the day provide you with jury instructions that ask a jury to find that is a cause of action. You've met the elements of the cause of action. We understand that as a remedy, but the reality is that's just a safekeeping step that is taken by attorneys that practice in this area, because you don't want to run the risk of having one dispute turn into a second lawsuit. But for those are the reasons, I'm happy to answer any questions you have, but those are reasons why we believe the motion should be dismissed. We should be having these discussions when you actually have a factual record in front of you after we've done some discovery.
Did we get the attorneys back on page 2?
Yes, Judge.
Hang on one second.
Yes, Your Honor.
Did you get him? Do you want to
Yes, he is on there.
all right, can I just call this?
Absolutely, Judge.
Rule 16 quick.
Recall page 24, Fred Brunner versus Melanie Sterling, A923202.
Hey, Your Honor. I appreciate all the court's time and attention. Certainly has had a very crowded calendar. Much work has had to be done by you and your staff.
All right.
In response to Mr. Morris's argument, Mr. Morris begins by criticizing the motion by citing and attaching 67 pages of exhibits, which were simply the 3 prior complaints or prior versions of the complaint filed in Arkansas, as well as the order dismissing the matter in Arkansas. So the court would have the ability to understand what had happened prior to the initiation of this action here in Nevada. Furthermore, Mr. Morris tells this court that those exhibits were never cited to in the motion. Like many of the statements that were made in oral argument, that is false. Cite to page 7 of the motion, line 15. That same cite, specifically to Exhibit A, paragraph 2, was reiterated on page 5 of the reply. There was not some scheme to effectively sandbag or otherwise move the ball on the plaintiff. To the contrary, Judge, the position that defendants had remains consistent. Moreover, Your Honor, we talk about the fiduciary duty issue. I am appreciative of Mr. Morris's citation to the decision, specifically to the Valley Health Systems, as well as the Giles decision, neither of which, by the way, were cited to by the plaintiff in their opposition briefs. But the important point to that effect, Judge, is that whether you're citing to those decisions or to the Hoops versus Hammergan decision, which was explained in detail by Mr. Morris, the law remains the same. And I will read from the Hoops versus Hammergan decision, because the holding there was not unique to those facts. The Nevada Supreme Court said the essence of a fiduciary or confidential relationship is that the parties do not deal on equal terms. Since the person in whom trust and confidence is reposed and who accepts that trust and confidence is in a superior position to exert unique influence over the dependent.
I think what counsel was saying was not that it wasn't in the case, but it was only in that case.
Perhaps in terms of
Not
that language.
mistaken.
Yes, but then when Mr. Morris cites to Perry versus Jordan, which has been cited to throughout the consistently by the Nevada Supreme Court concerning fiduciary confidential relationships, that Perry versus Jordan case also has facts which are extreme. In that case, the plaintiff had an 8th grade education. The defendant had a significant amount of experience in business, was her neighbor, so much so their relationship was so close they called each other sisters. The defendant in that matter had been trying to sell her business. The plaintiff, trusting her neighbor, friend, person who she can consider close enough to call a sister, said, "I'll buy the business from you." And what did the defendant do? Sold it to her for $100,000 more than what she had put on the open market, and then attached an additional $5,000 to the purchase price for a computer system that had already been purchased by someone else. Perry versus Jordan is a clear example of the disparity in power, the reliance and trust from the dependent individual, the plaintiff who had an 8th grade education, trusting her sister, or the person who she would consider to be a sister, someone with much more advanced experience, much more
So
sophisticated.
the power comes from the education, the power comes from the relationship.
Correct, Judge, but the relationship is based upon it. One is not divorced from the other. The reason why the relationship exists and the reason why the trust exists is because of the imbalance in sophistication.
I don't know about that. I'm not sure I see that.
There has not been a single case that has been cited by Mr. Brunner anywhere in Nevada or anywhere else in the United States in which the sophisticated business person is the dependent individual. The one with all the money is the dependent individual. That's the import of this. There's a reason why boyfriends and girlfriends do not have fiduciary duties or confidential duties towards one another. It's why there's never been a single case cited by Mr. Brunner holding that such a relationship exists. The best they have is Fick v. Fick, which, Judge, the Nevada Supreme Court confirmed it was unique to the relationship of fiancés. In that decision, the Nevada Supreme Court states, "We have acknowledged that fiancés share a confidential fiduciary relationship. Each has a responsibility to act with good faith and fairness to the other. Such a responsibility contemplates that each party will make a full and fair disclosure prior to the execution of a premarital agreement." Again, fiancés, individuals contemplating marriage, negotiating a prenuptial agreement, none of which happened here. The court was right to ask the
But do you
question.
think it's because of the fact that they were fiancés, or do you think it's because of the relationship, i.e. a monogamous, continuous relationship, and the subject matter, the prenuptial, or the tending to property? You know what I'm saying?
I appreciate the court's question, and I would respectfully submit to the court that the Nevada Supreme Court, both in Fick and Cantor, which has repeated the holding that there is a confidential or fiduciary relationship between fiancés, is that is unique to that relationship because they contemplate marriage. That is, the marital relationship is also another relationship for which there is a fiduciary duty. But boyfriend-girlfriend is not one for which there exists such fiduciary duty, because marriage is unique in the state of Nevada as it is in all 50 states in this country. We treat it in a particular way. We give it deference in a way we don't give other relationships, which is why in the Markle decision, that is from the Texas Appellate Court of Appeals, they recognized paramours do not have a similar relationship. And in response to the citation to the Markle decision, Mr. Brunner states that that decision is distinguishable because that contemplated an extramarital relationship. Precisely what was happening here. There was an extramarital relationship by Mr. Brunner as he was still married to his wife at the time.
Hey, I don't know
The-
facts, never mind.
But the reality is that that is true. Paragraph 13 of the complaint admits that they were that he was still married to his then wife at
The
the time.
extramarital affair to me means though that you're going along the way with your marriage and your spouse has no clue what's going on and you're having an extramarital affair.
Mhm.
Having a relationship while you're still married, but potentially seeking divorces. In my mind, not the same.
I wish, Judge, every single one of my male divorce clients pending going through a divorce would listen to the court in that regard. It's certainly a holding they would love. My point is, Judge, the divorce hadn't even proceeded yet. Not even initiated until December 22, 2020, of 2014. And that's not argument of counsel. That's the citation to Exhibit A, paragraph 2. That comes from Mr. Brunner's own complaint filed in Arkansas. That's the point, for which this court, by the way, could take judicial notice all day. Because it's not a question of fact. It is simply, you look to a filing of the initiation of a complaint for divorce. No, excuse me, the filing of a complaint for divorce. The court appreciates this issue. The statute of frauds bars any claim of an interest in this property. There can be no fiduciary duty between boyfriends and girlfriends. And the notion that one trusted the other without regard to the other parts of this relationship, which the court was right to ask, how often were they together? Mr. Morris does not know the answer to the question, but I do. Throughout a 10-year relationship, the longest they had ever been together, Judge, in a row, was 2 weeks. In most cases, it was about once a month, sometimes every other month, for about a week or so. That was when they saw each other. This was not the live-in boyfriend situation, boyfriend-girlfriend situation. This was nothing like that. And when we talk about the facts, they never plead any of these facts. The reality is, it was a long-distance relationship in which they saw each other maybe a quarter of the time, maybe a little bit less. That is a far cry from a confidential relationship akin to that of a doctor or a patient, a lawyer and a client, a sister and a sister, or a next-door neighbor in which they've got a relationship like sisters. There's nothing like that. And there's a reason why we don't have any of that authority, not just in Nevada, but elsewhere, because it doesn't exist.
So he spent a whole lot of money on a whole little. I mean, is that?
I mean, it was a 10-year relationship, Your Honor. And the reality is this. It was a whole lot of money for the vast majority of the population. The question, though, is, was it a whole lot of money for him? And he made the decision that it was worth it to make those purchases, to give those gifts. When the court was confronted with a question from Mr. Morris,
And I'm not so concerned about the gifts. It's more about the monies like the house.
correct, Judge, which is why this case is about the house.
Isn't and that's all we're here about, right?
I would not speak for Mr. Brunner's complaint or Mr. Morris's.
Right?
Your Honor, I believe the house and the improvements to the house are the main issues that
We're
are.
not looking to get reimbursed for taking her on cool trips or any of that stuff. It's strictly on the jewelry or whatever else there was.
Correct, Your
It's
Honor.
just the house and the improvements.
Which is why the court must dismiss this matter because of the statute of frauds. Because there was no such relationship upon which a constructive trust can be established. And Mr. Morris told this court that the breach of fiduciary duty claim, or excuse me, the fiduciary duty was not essential to a constructive trust. And yet he then reads from Town versus Long, the citation that says an essential element of this is a confidential or fiduciary relationship. The point is, Your Honor, as a matter of law, there is no such fiduciary relationship, and the court can make that finding, must make that finding. Whether or not a duty exists is
I'm
one.
gonna need to reread the cases, because here's what I'm thinking, and I told you up front. I don't think when we bought her the house, there were any strings attached. I don't think she made any promises, and she did, oh well. But if there was some kind of ongoing promises and he was under some idea that there was an exclusive relationship, and based upon that, he was investing in the house, then I would be more inclined, if the law allows me to do that, to give him some recourse on that if in fact she's basically lying to him. And he's giving her the additional monies because of those lies, if you will.
In Your Honor,
That's just, I'm still gonna go back and read the cases, and I could come back and flip flop both ways, you don't know.
and I appreciate the court's close review of this. I know the court had studied the papers before our hearing today, and certainly the court is wishing to make sure that it has a full appreciation of the legal landscape as well as the factual landscape within the complaint.
My best advice is that you guys get yourself a settlement conference and figure this out rather than spending all the money on the litigation. You have a limited pot and I would call Judge Weiss or your civil judge or any judge of, all the judges will hear, most of the judges will hear a settlement conference. You could give them a call. I can't fathom that this would take too long.
And we
That's my
certainly,
opinion.
we certainly, Your Honor, will explore that. I know that Mr. Morris and I have discussed potential opportunities to resolve this matter. I do want to point out to the court, though, given the fact that I think that we're not going to get a decision today, and that if the court does not dismiss, when the court talks about these representations.
I don't anticipate dismissing it in its entirety, just to give you that heads up.
No, I appreciate that, Judge. But I do believe that the court, in many ways, the last 30 seconds really has distilled this entire case down, which is you have a situation in which there's a question of whether or not there was representations concerning exclusivity, and that the relative cost of this is substantial attorney's fees. And if this court were discovery to bear out that there either was no such representation, or perhaps that Mr. Brunner himself was not so faithful, that the court may entertain awarding attorney's fees to the
Oh
defendant.
my goodness gracious.
Because I can tell you, Judge,
Oh my gosh.
that is where we're going, Judge.
Righty.
I appreciate the question.
Can't wait.
Your Honor, the only thing I would ask, and I'm not gonna, it's not it's really not an argument. I understand the court wants to review the authority. I would ask that before the court reviews the authority, the court sit down and read our complaint and the allegations in our complaint, as opposed to the characterizations of our complaint, please.
I'm gonna read everything. If y'all wanna send me your top handful of cases that you think are your best supporters.
And then the key I wanted to focus on is the word confidential relationship. It's used throughout our complaint. And again, Mr. Jimmerson wants to focus on this
I'll look at
fiduciary.
it. I mean,
it's a breach of fiduciary duty
it
claim.
seems like humans owe each other, just generally speaking. I shouldn't lie to you to make you do something. Whether we have a relationship or not, it just feels.
And I will say,
Right.
we have our response did request, and we said if the court is inclined to dismiss any portion of the complaint, we would request leave to amend. And part of the reason for this is the Nevada does recognize a cause of action for breach of the duties stemming from a confidential relationship. So if this court were to come back and agree with Mr. Jimmerson and say, yeah, this is a bridge too far, we're not going to give you a breach of fiduciary duty, we would want to amend to file an amended complaint that would replace the breach of fiduciary duty claim with a cause of action for breach of the duties flowing from a confidential
I do
relationship.
respectfully request, Your Honor, that would be in motion practice, because obviously we want to see what the allegations would be. Moreover, Judge, I think the court appropriately hit the nail on the head when it said, you got a duty not to lie to each other. You're right, Judge, that's fraud. And so if the court believes that's been adequately pled, then the fraud claims should remain, but the remaining claims, fiduciary duty claims, those other claims would not survive the motion to dismiss.
Okay, how are we looking in the next? At least 2 weeks. We're close to the 30 days. 30 days, 30 days. November 18th,
November 18th at 10 a.m.
does that work?
Just double checking, Your Honor, I appreciate court's indulgence for 10 seconds. Yes, Judge.
Work for you?
Sorry, Mr. Jimmerson's faster than I am. Yes, Your Honor, it does.
Alright,
And just so I'm clear, what are we returning on November 18th for?
I'm gonna reread the cases. I don't need you to start from square one. I may ask questions though, so. Don't send somebody that doesn't know anything.
I'm sure we.
And you're welcome to zoom in if you want to zoom as well.
It's a privilege to be in court, Judge.
And you had indicated that you were inviting the parties to send their 5 or so best cases. That's,
I'm not limiting you, whatever your best cases are. If you've got cases that. I've tried to jot down what I'm gonna make sure I reread. But if you guys send them to me, then I will read them, I'll highlight them, I'll do all that stuff.
Your Honor, I would propose 2 weeks simultaneous filing.
I mean, are we talking about it didn't sound like the court was inviting more briefing. It was literally just a submission of,
Yeah.
of
Give me
authority.
your best cases. for
Okay,
the
so
week.
there's no argument that it's just a submission of case law, that's fine.
This week.
Okay, it didn't,
And we can coordinate and see if we'll try to make it so we aren't submitting the same cases. We can arrange that.
yes or no?
What, but that's also kind of cool, because that tells me something. So feel free to double up,
Okay,
because you both like the case, you know what I'm saying?
Okay.
So.
fair enough. Then we will not cooperate. We will not communicate.
All right,
Thank you, Your
guys.
Honor.
Thank you, have a good day.